Hi, Assalamualaikum warahmatullahi wabarakatuh, and a very good evening I bid to my lecturer, Dr. Rosanna, and also my fellow friends. Okay, in this course of MGM 4331 Industrial Relation and Employment Law, I am going to do a video presentation or an oral test for test 2 with the topic of minor and major misconduct in employment. So, without further ado, let me introduce myself first. So my name is Lidiya Zulaikha Binti Khairul Annuar, and my matrix number is EX03516. Okay, so what is actually minor and major misconduct of employment? You all must have been wondering, right? Okay, let me tell you guys first. Let me explain it to you. Okay, so starting from what is the meaning of misconduct? Okay, the meaning of misconduct is actually case laws define misconduct to be any conduct on the part of employee which is inconsistent with the faithful discharge of his duties or any breach of the express or implied duties of an employee towards his employee. Meaning here that misconduct actually defines an act or behavior of the employee regarding to the job, and an act of inconsistent of faithfulness or indecent behavior of the job towards the employer. Okay, so actually it is also known as a form of improper behavior or an intentional wrongdoing or a deliberate violation of a rule or standard of behavior. Okay, so moving on. So let me tell you about the misconduct. Okay, which section of Employment Act of 1955 deals with misconduct? Okay, so in this case, it shows that in Section 14 of the Employment Act 1955 provides that an employer may punish an employee on grounds of misconduct after due inquiry. Meaning, the Employment Act provides that the employee may punish the employee if they found that the employee um, are did an act of misconduct. Okay, so due inquiry means the company must investigate. So before the employer um, are doing a judgment of the act of misconduct of their employees, so they need to do an inquiry first. So in this inquiry means that the company must investigate first of the misconduct of the employees and the case, and provide the employee an opportunity to defend himself before an independent panel before judgment is put on him. Meaning here that if a misconduct is happened in a company and the employer would make a judgment, they would have to make an investigation first, and due to that the employee would have the chance to actually defend themselves if they tend to did an act of misconduct by not in purpose. So in section 14 said that it goes on to provide that while investigating this matter, the company has the right to suspend the employees as well. Okay, so that moving on, I would like to ask you, why is it important to act on misconduct cases? Do you want to know why? Okay, so let's move on to it. So actually, why is it important to act on misconduct cases is because an employer who continues keep an employee in an employment with full knowledge that the employee has committed a breach of duty or misconduct condones the breach, and such waiver of retroactive permission and prevents the employee from later punishing the employee for it. So meaning here that the employee who continue keeps the employee knowing that they actually did a misconduct. It's actually very harmful and very dangerous for the company, for the employee to work in the company. So many HR or many human resources practitioners in Malaysia may be guilty of this. It is, however, dangerous to condone action because it will almost be impossible to act on it eventually. Like I mentioned earlier, like I said, many human resources in Malaysia, in company in Malaysia, they know that their employees actually did a misconduct in employment, but still some of them did not make an act on it. So at the end of the day, the company might be harmful, or might be dangerous with the employees that made a misconduct in the company. So moving on, okay, like I said earlier, the topic is about minor and major of misconduct in employment. So what is minor misconduct and what is a major misconduct? So what is major misconduct and what is minor misconduct? Okay, let me differentiate. How to differentiate actually? Okay, you must be wondering. So let me just differentiate for you. So differentiating minor and major misconduct is actually there is no hard or actually fast rule on what constitutes major misconduct or minor misconduct. The Employment Act of 1955 does not make reference to the words major or minor, meaning that it does not actually matter. The case is actually the act of misconduct, but the act of misconduct actually is 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 actually provided into two, which is the minor and misconduct, which is the minor misconduct and also the major misconduct. It is it is in two element, the minor and major. So the companies generally like to differentiate major and minor misconduct by identifying different types of punishment on both categories of misconduct act. So actually the minor and misconduct, how to differentiate is basically based on the misconduct act and also the punishment as well. So in fact the list of minor and major misconduct is subjective and might vary depending on the nature of the business. So for example, I'm going to give you an example. Okay, so actually answer the question of minor and major misconduct. It really boils when the nature of your industry is actually facing the misconduct of the company. So I would put the misconduct that is serious enough to warrant a termination as major misconduct and the others as minor misconduct. Meaning here, the misconduct is actually very serious that it could warrant termination as major misconduct and the others as minor misconduct. Meaning here that if major misconduct, it could lead to termination of employment. So however, an employee who habitually commits acts of minor misconduct will be deemed to have committed a major act of misconduct. For example, okay, so minor misconduct could be coming late to work. So but coming late to work is actually a minor misconduct. It could not lead to termination, but if it becomes a habit, meaning the employee tend to come work late, it might be most of the time or every day until it becomes a habit, then it might lead to major misconduct, meaning it is already serious that it could lead to a major misconduct because it is getting serious and it's not a minor misconduct anymore based on the company. And also, okay, you guys must be wondering like what is actually the example of minor misconduct, what is actually the example of major misconduct. I could not differentiate, I do not know. Okay, let me tell you guys. So actually I'm going to tell you from minor misconduct first. Okay, so minor misconduct is actually something an act which is actually a bit minor, a minor misconduct that is happening in the company. So one of the one of the examples are actually late coming to work. The employees are coming late to work. Those are one of the examples. And also leaving the workplace early, meaning actually the employee needed to leave the work at 5 p.m. but he left the work early at 4:30 p.m. It looks very simple, but it actually is a minor misconduct. And also absenteeism, usually less than 2 days. Absenteeism is okay if is okay by the company if there is a proof of medical certification, meaning that there is proof that the employee is actually sick and could not come to work. But if the absenteeism is actually more than 2 days without any reason, then it could consider as minor misconduct as well. And also a quarrelsome at workplace, it's not fighting but it's quarrelsome meaning you fight with your mouth, you quarrel with somebody at your workplace. And also carelessness causing minor damage to company's property, meaning you did not take care well of the company's property, which is from the carelessness of the employee itself. And also removing or or defacing or destroying company's notices. The notices in the company, they are destroying the notices. It is also act of of minor misconduct. And also failure to wear uniform at workplace. Looks simple, failure to wear uniform at workplace, but in some companies they already provide the certain uniform that needed to wear. But if they fail, it is also considered as minor misconduct of the company. And also they have failure to furnish information, malingering and feigning illness, and also loitering during work hours. Smoking in restricted areas is also a minor misconduct. And also not only that um it's actually not only that, failure to follow safety procedure in the company, infringement of safety regulation which does not cause damage to property or person, unnecessary wastage of documents and materials, abuse of company's property, which is actually vandalism, or refusing to accept servicing of documents from company, negligence in the care of tools, equipment, and apparatus, meaning the employee did not take good care of the tools and equipment or the apparatus, and also failure to keep workplace clean and tidy, and also obstructing other employees from work. Okay, so that is the minor misconduct, the examples of minor misconduct. For now, we're going on to major misconduct. Okay, what is major misconduct actually? Okay, actually one of the examples of major misconduct is misappropriation of company's money or property, meaning the employee did not take care well of the company's money or property, meaning the cash flow of the company is not organized or not well taken care of. Also thief, privilege of company's money property, meaning stealing or being a thief in the company. Fraud, dishonesty or falsification, meaning falsing something in the company, or dishonesty is also considered as major misconduct. Also cheating the company is also a form of major misconduct. And then fighting with other employees or visitors. Okay, fighting with other employees or visitors. Just now, quarrelsome is considered as minor misconduct, but this is fighting. Fighting is already leads to major misconduct, which is very serious, that could lead to termination. So assaulting another employee or visitor, soliciting or accepting illegal gratification, participation in an illegal strike, willful insubordination or disobedience, and also breach of fiduciary relationships, spreading malicious rumors about the company, that could also lead to major misconduct. Gambling in the company premises, gross negligence and neglect of duty, willful damage of company's property, sleeping while on duty. Okay, sleeping while on duty actually looks very simple, looks very an act of very light act, a very simple act. But I'll give you an example. Okay, hold on. Okay, I'm back. Sorry, my battery died. Okay, so let me give you an example of sleeping while on duty, which considered as major misconduct. Why is it? Because it sounds very simple, sleeping while on duty, but sleeping while on duty. Okay, let me give you an example. For example, okay, the employee is actually working as a security guard, but then the security guard sleeps while on duty. That could lead that the thief actually came and invade the company and steal everything which is in the company, meaning stealing the company's property and so on. So it looks simple, but sleeping while on duty is actually a major misconduct that could actually lead to termination, because like I mentioned earlier about the example, the security guard just sleep while on duty, but it gives a really big impact that it could lead to people to the thief came in the company and steal the company's property. Okay, so moving on, the possession of a legal weapon, meaning the employee has a legal weapon, breaches or indecent behavior, smoking in prohibited areas, drunk while on duty. So, okay, drunk while on duty is also a major of misconduct. Okay. So, moving on. Okay, can misconduct actually terminate employees? You guys must be wondering about this, right? So yes, actually, the terminating of employees with misconduct actually happens, which is from the major misconduct. So actually, employees in Malaysia are granted security of tenure from the day they are employed. Section 20 of the Industrial Relations Act of 1967 provides that any employee who feels that he has been dismissed without just cause and excuse may file an action for reinstatement at the Industrial Relation Department. As such, the contractual notice of termination cannot be served before the employer establishes a ground for termination to happen. So meaning here that the contractual notice of termination cannot be served before the employer actually establish the termination. So examples of grounds for termination would include a misconduct, poor performance, and also indecent behavior and so on. So actually in Malaysia, the employees are granted very safe security. So if the employees actually made a misconduct, then the employees should actually make an act to it or proceed with the judgment. Okay, so moving on. In matters concerning employee misconduct, it is actually well settled that due to the process must be followed, meaning there are procedures or steps that need to be followed before the employees are being judged or acted by their misconduct. Okay, so actually in here, in simple terms, that the adherence to the principles of natural justice. So, in simple terms, the employee must be given an opportunity to defend his case before an independent panel. The first step is actually to this is the issuance of a show cause letter. If admission is obtained, there is no need to proceed further. But if the employee denies the charges meted out against him, then the employee will have to investigate further through a domestic inquiry. So, meaning here that when employee is actually caught made and a misconduct in the company, the employer could actually made an act. They could actually judge they could actually punish the employee. But then before punishing the employee had an opportunity to actually defend themselves. So if actually it's right, the employee made a misconduct, then actually the punishment will just proceed just like that. But if the employee actually defend himself that he did not act the misconduct, um, the the employer had to make a further investigation through the domestic inquiry. So meaning here that even though the employee could punish the employers could actually punish the employees, but before that the employees need to make an investigation first before proceeding in punishment for the employees. So in here, okay, so factors to take account before punishing. Okay, what are the factors? Okay, before deciding on punishments, employees should take into account past records of the employees, performance indicators, years of service of the employees, general behavior of an employee, level of seniority. So meaning here that before deciding a punishment for the employer need to take note and take the records, the list of records here of the employees before proceeding of punishment. So these are actually mitigating factors that should be taken into account before punishing an employee. So moving on. Okay, is notice required for termination with misconduct? Okay, meaning here that for termination for misconduct, is the notice actually applicable for the employees? So to answer that question is actually no. Once an employee is found guilty of misconduct and the company decides to punish an employee, he is not entitled to get notice and can be terminated immediately in the section of 14.1 of Employment Act 1955. So any unutilized annual leave will be also be forfeited. So meaning here that once the employee is found guilty, there is no need for the employee to get notice. The employee can just right away terminate the employee immediately, such as if the employee is drunk while on duty, he is actually picking up a fight with other employees, the employees can immediately terminate the employee. Okay, so moving on. So I'm going to tell you about the misconduct out of office hours. So misconduct out of office hours can disciplinary action be taken against an employee who does something inappropriate outside office hours and outside the company premises, meaning the employee is doing the act of misconduct outside of the office and not during the office hours. So the law entails that employees can hold an employee accountable for his conduct if they can successfully establish sufficient nexus between the employee's of duty conduct and its importance of the business and image of the employer. So meaning here that the law said that the employees can hold the employee accountable for his conduct, and if they establish sufficient nexus between employees of off-duty conduct that is important for the business and the image of the employee to actually take an action. Okay, so the common law position was highlighted in the case of this one case. I would like to explain. I would like to let you know that there's this one case which is actually the post office versus Lidiya, which has happened in 2001, EWCA Civil 940, whereby the employees involved in football hooliganism during the World Cup has brought bad publicity towards his employer, meaning here that the employee's involvement here actually gave a bad publicity, a bad image to the employer, that the court found the dismissal valid as his conduct had brought into disrepute. So that is the case for the post office versus Lidiya in 2001. So the similar cases in Malaysia too had happened, which is the misconduct in Malaysia. So those one of those similar cases in Malaysia is one of them is Prawira Habib Bank Berhad versus Tusuf bin Zakaria in 1995, 1 ILR 123. So the court upheld the decision to dismiss one of their bank managers who had allegedly engaged in illegal activities outside of his employment. So the court actually held that as the bank manager was a senior executive and must maintain a high standard of conduct, as such as the illegal conduct would prejudice the bank by not disrupting its business but causing disrupt. So meaning here actually the court upheld the decision that actually the bank managers, they actually engage in illegal activities outside of the employment, and the court said that they made an investigation, and as the bank manager they should not do such illegal conduct which prejudice the bank itself. So that is one of the cases that's happening in Malaysia. Okay, and then next case is actually drinking during social events. Like I said earlier, that drinking while on duty is actually a form of major misconduct. So what happened here is that it is between Maitul Tosin Jan Berhad versus Annuar bin Hassan in 1996, 1 MELR 294. So it was happened here that the employee was alleged to be drunk and has used force against other guests, damaged property, thrown napkins, toppled chairs, and shouted at other employees. So meaning here what he did was actually most of all the major misconduct in an employment. So the court actually found dismissal was unfair, although the employee was fully drunk and misbehaved. The issue was at the company let off another senior manager in similar second with a warning. Therefore, the treatment was unfair. Meaning here that the court found it that the actually what happened here, the employee is actually really drunk, and they actually he actually made a really major misconduct in the company, but the company still gave him a chance, knowing that he is actually the senior manager, and then he also the company also let him off with a warning. Therefore, the court found the treatment was really unfair because it is already a major misconduct that could lead to termination. Okay, so the next case is actually about the emails sent using personal computer outside of work. Okay, actually, this case was between Ghostin versus Lifeline Project Ltd. So as we know, in if we have a job or in a company, the employees is provided with a certain company email or provided with a company laptop itself. So in this case, the employee during his off hours received a chain email on his home computer which contained racist and sexist materials with the instruction to forward to others, meaning to forward to his colleagues, and then the colleague forward to another, and it ended on company's intranet, meaning that it became a chain in the company of the forwarded sexist and racist materials that has been forwarded. So the company dismissed the employee on the basis of gross misconduct, and then the tribunal upheld the dismissal that the claimant should have been aware that those person he sent is actually making a major misconduct in the company, which he actually used the company's personal computer and also give a bad image of the company. So this is one of the cases that is happening in Malaysia, which is Ghostin versus Lifeline Project, using the emails of the company, the email company. Okay, so that's all for the cases, the two cases I have explained. So moving on the practical tips. Okay, so the practical tips is actually an additional, but I just wanted to share it with you guys. So the employee should not practice double standards, meaning employee should not give any other chance, or actually should not actually have another second thought, which when dealing with potential misconduct, because it could give a really bad it could really give a very bad effect to the company as well. It is actually very harmful and also very dangerous to the company. And then the same level of punishment or disciplinary action should be meted out for the same type of misconduct, meaning that if that person have actually made a major misconduct such as drunk, it is actually not fair for him to let him off with just a warning notice. So here it must be very fair, so that if that person is drunk while on duty, then that person must undergo the punishment. He must go through the punishment and maybe go through suspended or even termination, because it is already a major misconduct. Okay, so next, moving on. So the employee should also act reasonably and comply with procedural fairness, like I mentioned earlier, before terminating an employee for misconduct which took place outside work. Minor misconduct may not warrant termination, like I explained earlier. Minor misconduct could not lead to termination, and then especially if the employee has shown genuine remorse and has promised and did not want to repeat the same action. Like for example, the employee came late once came late to work once and already showed that showed the genuine remorse that he did not want to repeat again, then it is considered it is considered fair. It is considered fair. And also prior to termination, so if that employee came late to work for once, then it could not lead to termination. It's just a minor misconduct. But prior to termination, employees should be made aware of the allegations made against them and be given an opportunity to explain their conduct, meaning major misconduct, meaning such as the termination can be happen due to meaning indecent behavior, meaning a possession of illegal weapon, or drunk while work, or illegal or bringing illegal substance to work. Those are the examples that could lead to termination. So employees should have the burden to prove when it comes to unfair dismissal cases, meaning the employees have the right to punish the employees, but they must make an investigation and also must have the proof that the employees are actually made and misconduct in the company as well. So as such, a dismissal for misconduct must be supported by evidence and should not be premised on mere allegations or rumors. So the evidence here, so if the employee is found and misconduct, the employee should have an evidence, and not only based on rumors. So employees should assess the evidence available and seek legal advice before dismissing an employee for misconduct. So I think that is all for now. I think I have explained enough for today, for this topic of minor and major misconduct. I hope you all learned something today from what I have explained and presented today for this oral test too. And also, I hope you guys learn a little bit, more or less, from what I have explained today. I hope you guys learned something. So without further ado, let me end my presentation today here. So thank you so much for listening. I hope you guys learned something. So for that, bye and assalamualaikum warahmatullahi wabarakatuh. Thank you.